Speaker, and before I begin on my prepared text, I'd like to read out a Facebook page from Mr. Rodney Stafford, who is from my riding, and it starts off by saying, Rodney Stafford is feeling angry. I'm really trying to find the words to say right now. There are so many questions that have been unanswered regarding Terry Lynn, and I'm never going to rest until justice is upheld. Now, knowing that we've all been fighting over the last 3 months, and the questions asked without real answers and runarounds, it has come to my knowledge as of today that Michael Rafferty, the man responsible for all actions the day of April the 8th, 2009, the abduction, brutal rape, murder, and concealing of evidence, was transferred from his maximum security facility to a medium security facility in March. This means that all this time, over the last 3 months, Corrections Service Canada and our Canadian government has been hiding the fact that not one, but both people responsible for stealing the life of Victoria have been working their way to luxury. Where in the world does it make sense that the worst of the worst criminals, not petty thieves, the worst of the worst child killers, even get the opportunity to better life? So now there are 2 child killers living in medium security penitentiaries with frequent day passes, medical, dental, and schooling and access to air. I need Canadians everywhere to help this fight. Our children and lost loved ones deserve justice and security within our country, and I am so ashamed to be a Canadian right now. During our meeting with Ann Kelly, Commissioner of Corrections, she was blatantly asked by Patrina if there was information about Rafferty that we didn't know about. Another dodged question. Corrections Service Canada needs an immediate overhaul, as this is what they consider justice. 3, not 1, but 3 appeal judges on October the 24th, 2016, looked Michael Rafferty's lawyer in the face, and they all stated he was right where he belongs, same as the trial judge. So Corrections Canada, a year and a half later, says, no you're not, and lowers his security and transfers him, yet again without making contact with me regarding his transfer. Think about it. That means during the rallies and all this time that Canada has been fighting for real justice for Victoria and all of our loved ones regarding the lowering of security and transfer of Terry Lynn, Corrections Service Canada has withheld this information about Michael Rafferty. I only received the information because I had requested it, even though I was asked. There really hasn't been much activity in Michael Rafferty's file. Would you still like me to send the information to you? Oh yeah, I said, glad I did. Thank you for taking the time to read this, and please share the snot out of this if Commissioner Ann Kelly is willing to sit and slap me in the face over and over again with the tragedy of having lost Victoria to 2 brutal killers the way we all did. Who is she willing to screw over? This is completely unacceptable on every level. Child killers. And that's from Rodney Stafford, the father of Terry Lynn Stafford. And it just shows, Mr. Speaker, I think there's a justice issue that all Canadians feel very important. In this case, the father has made his feelings very clear. Now, Mr. Speaker, I'd like to share my time with the member from Sarnia-Lambton. And I would say to you, sir, that I am pleased to rise in the House to speak to Bill C-51. The purpose of this bill is to streamline the Criminal Code of Canada by moving certain provisions that no longer have relevance to contemporary society. C-51 is a Justice Omnibus Bill. It's one bill that contains many changes in a variety of different matters. The Prime Minister and his Liberals called omnibus bills undemocratic, and the Prime Minister pledged that a Liberal government would undo the practice of introducing omnibus bills. Regardless, I along with my Conservative colleagues are aligned with the strengthening of the provisions of the sexual assault legislation. Former Conservative leader Rona Ambrose led the way for supporting victims of sexual assault by introducing Private Members Bill C-337. This bill would make it mandatory for judges to participate in sexual assault training and education to ensure that the judiciary is aware of the challenges sexual assault victims face. Her bill was designed to hold the Canadian judiciary responsible for the ongoing training of judges and the application of law in sexual assault trials. As we'll all remember, this bill was passed in the House of Commons, and we were hopeful it will pass in the Senate. It has not passed as yet, Mr. Speaker. We are pleased the Liberals are planning to strengthen sexual assault provisions in the criminal code surrounding consent, legal representation, and expanding the rape shield provisions. The Conservative Party stood up for the rights of victims of crime when the Canadian Victims' Bill of Rights passed in 2015 and will continue to do so in the future. Bill C-51 would amend, among other things, Section 273.1 to clarify that a non-conscious person is incapable of consenting. This is a reflection of the Supreme Court of Canada's decision in Regina versus J.A. It proposes to amend Section 273.2 to clarify the defense of mistaken belief is consent is not available, and if the mistake is based on a mistake of law, for example. If the accused believed that the complaint's failure to resist or protest meant the complaint consented. This bill would expand the rape shield provision to include communications of a sexual nature or communications for a sexual purpose. These provisions provide that evidence of a complainant's prior sexual history cannot be used to support the inference that the complainant was more likely to have consented to the sexual activity in issue, or that a complainant is left worthy of belief. Now, Mr. Speaker, in addition to that, this bill would provide that a complainant would have a right to legal representation in rape shield cases. It would create a regime to determine whether an accused could introduce a complainant's private records at trial, which would be in his or her possession. This would complement the existing regime governing an accused's ability to obtain a complainant's private records when those records would be in the hands of a third party. Another aspect of Bill C-51 that I strongly support is the removal of unconstitutional sections of the Criminal Code. Canadians should be able to expect that the Criminal Code accurately reflects the state of law, and yes, Canadians who made that common sense assumption could be wrong. I agree with a few other revisions, for example, the removal of Clause 41 of Section 365 of the Criminal Code, which states everyone who fraudulently A, pretends to exercise or to use any kind of witchcraft, sorcery, enchantment, or conjuration, and Clause 4, the removal of Section 71 pertaining to dueling in the streets. Everyone who A, challenges or attempts by any means to provoke another person to fight a duel, attempts to provoke a person to challenge another person to fight a duel, or accepts a challenge to fight a duel. There are a number of provisions to be removed. And obviously, Mr. Speaker, the sections dealing with dueling are long overdue to be removed. One other aspect about C-51 is the fact that government has finally backed down from the removal of Section 176 from the Criminal Code. One of the parts of the bill is to remove unconstitutional sections as well as sections of the Criminal Code that, in the opinion of the government, are redundant or obsolete. Mr. Speaker, there's been much discussion on Bill C-76. And what's most interesting is that the minister brought this bill before Parliament on June the 5th, 2017. And ironically, on June the 9th, 2017, a criminal court case in Ottawa dealt with that particular bill. It would seem, or that particular section of the code, it would seem there had not been a great deal of research by the government on what that really meant. And it's fair to say that Section 176 of the Criminal Code makes it a criminal offense to obstruct or threaten a religious official or to disrupt a religious service or ceremony. Section 176 is not unconstitutional. It has never been challenged in the court and is not obsolete. Actually, a number of individuals have been successfully prosecuted on that. Also, it is not redundant, as the only section of the Criminal Code that expressly protects the rights and freedoms of Canadians to practice their religion without fear or intimidation. Religious prejudice shows no borders and has no respect to persons. That is why I'm glad the government finally listened and to the thousands of Canadians who signed petitions, wrote letters and emails, and made phone calls to MPs and the government to keep Section 176 in the Criminal Code. There was one other section of the code I did not agree with removing, and that is the section that has specific protection if someone attempts to attack the Queen. We all know this section is not used often. Matter of fact, probably never. But as state visits are rare, it should still remain in the code because it does protect that person who represents the monarchy in Canada. It's still a very serious crime, and if anyone attempts to attack the royalty as Canada's head of state, it is not the same as getting into a bar fight. It is important and it has significant aspects. That being said, I am pleased that the government is no longer scrapping Section 176. I am pleased with the clarifications with respect to sexual assault. And Mr. Speaker, I am pleased that a number of sections that are taking up space in the criminal code no longer have any particular relevance are being removed. Thank you, Mr. Speaker.